Trinidad and Tobago.
Right, good afternoon, Mr. Moran Logan. Mr. Ali, can you hear us and see us?
I'm hearing well.
Very
I'm
good.
seeing well.
Good. Right.
Much obliged, my Lord. My Lord, I lead Miss Kate Temple-Mabe, and we're instructed by Mr. Ganesh Sarup of Freedom Law Chambers. We appear for the appellant, and my learned friend, Mr. Irshad Ali, Mr. Adam Razak. They appear for the respondent, instructed by Ms. Nalini Bansi of Invictus Chambers. My Lords and my Lady, this is an appeal from the decision of the Court of Appeal of Trinidad and Tobago, dated 24th of November 2023, overturning the decision of the trial judge of the 17th of February 2023. As a matter of housekeeping, I want to start by tendering an apology for the state of the record in this matter. My learned junior and myself, we were recently instructed in this matter, and I have to say it is not one of the better prepared records and the
Not
documents.
easy to navigate around.
No, it's not at all.
Yeah.
So my sincere apologies, my Lord. I mean, part of the reason for that may be explained, I'm advised, by the delay in commencing the proceedings. The contract was terminated, you may recall, in June 2009, and it wasn't until May 2013, just a few days before the 4-year limitation period was about to expire, that this claim was filed. And that may also explain, from a practical perspective, the appellant's state of records and witnesses. As you'd imagine, 4 years for a public authority, it's cutting it very close to the limitation period. So employees would have transitioned, moved on, and of course that's why they had the lone singular employee who was really merely testifying from the company's records, as it were. The background in brief is that a tendering process took place on the 23rd of May 2007, and a contract was entered into with the respondent for the design, supply, and installation of 28.43 kilometers of pipeline from Rio Claro to Mayaro. And the contract comprised 2 packages, one for 14.4 kilometers and the other package for 14.03 kilometers. The contract, and it's important to understand that Trinidad and Tobago, we have a very developed oil and gas sector, and we have a very developed manufacturing sector, so that the FIDIC type contract is something that is not novel and new to us. It is an international precedent that has been adopted and has been utilized in Trinidad for quite some time. And that's important because this particular form of contract is one where the contractor designs and maps out the building, and he then determines his own price. And that's significant because normally that would not happen, but it means that one has to be careful as a public authority in selecting a bidder for this type of contract, because you depend heavily on the integrity of the bid that is submitted by the tenderer. And the reason for that is you might exclude another person whose price may be probably less, for example. But if you do so on the basis that, all things being equal, the integrity of the design for which the contractor is responsible is intact for all, then you can see the problems and the pitfalls for a public authority, in that if a contractor then comes and says after the fact, after they've been awarded the contract, well, hey, I did a bad job or a deficient job with respect to the design, which impacted on the pricing, and I now wish to rectify that somewhat cleverly or disingenuously by saying, well, look, let's vary the scope of works. Now, that creates a lot of political.
The authority may end up actually paying more for the contract than another bidder who lost out because they looked as if they were going to be more expensive than. Correct,
and whose designs were more, more competently done. And that's the point. And because it's a public authority, the socio-political problems that presents in a small society is not to be underestimated. And that's why the transparency and integrity of the bidding process is something that we have to be very careful about. Now, in this case, I've seen from the respondent's written case that they now attempt to raise what we say is a new case altogether, and I red flag it for my Lord's attention, to say, because they now wish to say, well, having regard to the lapse of time between the site visit and the award of the contract and so forth, they didn't have enough time to actually ensure that they properly designed, formulated their designs. Well, that's just not on, because it's not a case that was run in the courts below. It's, it's arising for the first time, and it really is, it's an entirely new case altogether that we wouldn't have had the opportunity to meet and give any evidence about.
So, anyway, it's not obvious why there wasn't enough time.
Sorry, Miller?
It's not obvious why there wasn't enough time.
No, and it's certainly not a complaint that any other bidder would have made. And given the fact that there were site visits as well, and no complaint or objection was made by the contractor, they were free for. And one must bear in mind, when the underlying principle of freedom to contract is a double-edged sword, it also means that if you are unhappy about the window, don't bid. What you're not allowed to do is to submit a low bid and then try ex post facto to rationalize a deficient design and say, well, that now should give me a variation to the scope of works. I mean, to put this in proper context as to why this appeal is so important for the authority, this project was estimated to cost $28.6 million for packages 1 and 2. The contractor has been paid $21 million as at the time work stopped, $21 million. This claim is for a further $6.4 million when we had to complete the works, and it represents a 22% increase on the contract price. So it is not a small, shy measure that we are talking about. And we are dealing with a public authority that has to manage and spend public funds. Now, there are implications for a public authority outside of what I've mentioned, because WASA has to depend on its budget from the Ministry of Finance. And the budget that they will ask, obviously, as a public authority from the government would be largely predetermined by reference to the works that they intend to plan and execute and the, whatever bid is submitted. So that you could well imagine, being an essential service that they're providing, and water is an essential commodity. If they find themselves faced with unexpected claims, then they've got to find that money from somewhere else to pay that claim or to pay for this variation in the scope of works, which means ultimately, on a practical level, it means that there could be less water for actual human beings in communities in Trinidad, because the money's got to come from somewhere else in WASA's budget, obviously. And that's the practical reality of the situation. And that's precisely why the authority in this matter went about it the way they did for a fixed price lump sum contract. This was a FIDIC Yellow Book build and design contract. It was a fixed lump sum contract. The costs were to be fixed in advance and known to the parties in advance. And it's not that variations were not permitted. Variations are permitted by the contract. It has that inherent measure of practical elasticity. But the contingency amount within the fixed price was intended to cater for and accommodate any additional payment caused by those variations. And that is expressly provided for. There were clauses in the contract obliging the respondent to have satisfied itself ahead of time as to the sufficiency of the contract price. And there were strict provisions about the manner in which the variations could be instructed, approved, and valued. And one must obviously presume that it was the party's intention to be bound and honor those procedures. Now, my lords, those procedures contain, it contains procedural safeguards for a public authority, and that's why the FIDIC type contract is adopted by public authorities. And what are those procedural safeguards? The work site in this is not exactly in London or Port of Spain or capital city. This is a fairly remote part of the island. And one can well imagine that when in Maruga and Mafeking, where this work is taking place, which is not, as I say, in the urban area, it's a fairly rural part of Trinidad. And when that happens, on the work site, it is so far removed from the corporate headquarters of the public authorities, which are mostly based in the capital city and in close proximity to that. The engineer it's easy to for the engineer to form a relationship with the contractor. An alliance, a relationship, it happens. And that is precisely why these procedural safeguards are there to protect the public authority, to prevent any form of corruption, any form of working relationship, crossing lines and invisible lines in the sand that you wouldn't otherwise know about and have no ability to manage. Now, there is no pleading in this matter 4 years after the fact, when just days shy of the limitation period, about fraud or any corruption. But having said that, the cross-examination skirts close and hints at, that this could be an issue. I can't take it further than that, but what I will say is this. If the engineer, as a public authority's representative, willfully and knowingly, with his eyes wide open, and consistently breached those the procedural safeguards, knowing that the integrity of those procedural safeguards are to protect the public authority, then it really does not lie in the mouth of the engineer who testifies for the contractor. Not in response to a witness summons. He gives actual primary evidence as a primary witness for the contractor. And in those circumstances, it really is just not on to say that, well, look, we breached all of this, both the contractor and myself. We both breached it, but you're bound by this, even though there isn't a shred of evidence to say that the authority waived its rights under the contract to have this strict procedural compliance in what is a comprehensive and carefully calibrated procedure to govern the parties' relationship. And I want to say this as well. Insofar as Mr. Barry Paul gave evidence in this matter on behalf of the contractor and seems to have had an excellent memory to recollect what happened 4 years after, there is no pleading in the statement of case, because it troubles me as to why did the public authority not confront his evidence about the fact that he had sent some monthly reports to Mr. Robinson. Mr. Boyce, beg your pardon. It troubled me, but when you look at the chronology of the proceedings, there is absolutely nothing in the statement of case on such a substantial issue, which the Court of Appeal said was the clincher.
You're talking about waiver, are you?
Yes. And there was
no pleaded case, you're making the point, there's no pleaded case of waiver or estoppel.
No. And no pleaded case of waiver, no pleaded case of estoppel, and more than that, the point I'm making, my lord, is this. There is no pleading to say that Mr. Barry Paul, as the engineer, notified WASA via his superior, Mr. Boyce, about monthly reports on a regular basis. There is absolutely nothing in the pleading about
So you say their case was really that it was Mr. Paul, the engineer, who had agreed all this, but now it said that actually, because he reported to Mr. Boyce and others, that actually the high-ups at WASA also agreed to this, and you say that that wasn't something that was pleaded, or there was...
Correct. I said it wasn't pleaded, and they don't go so far as to crystallize the point, actually. They cleverly skirt around it But because they realize they didn't plead it, they don't actually take it to the logical conclusion. But the short point here is, it having not been pleaded, the first time that evidence emerged was when witness statements were filed and exchanged. That's the point. It was only when witness statements were filed and exchanged that Wasser, the appellant before you, knew for the first time that this person was making such an outrageous and important allegation that was a critical success factor for the respondent's case.
So witness statements are filed how long in advance of the trial?
It's, well, my lord, it depends on case management directions. Sometimes it's closed, sometimes it's not closed. I can't say when, how long.
But pleaded or not, you had notice of the point through the witness statements.
Well, yes, my lord. You would, when you get the witness statements, yes. But my lord, at that time, the way the rules operate in Trinidad, at that time, evidence is closed. You know, you've got to, all you can do at that stage is to cross-examine the witnesses. And that's precisely. And then on top of that, all the Wasser's counsel could have done in the cross-examination is say, well, these reports, which are so relevant and so important, where are they? Did you produce them for the court? And he says, well, no.
Well, I guess they were sent by your engineer to your client.
Well.
So actually, it wasn't as simple as them producing them, but they should have asked for disclosure, specific disclosure of them.
Well, my lord, well, remember, the way the rules are operated, you have the standard disclosure which takes place before, and then the witness statements come. Now, when you get the witness statements, you at that stage, pre-trial review has taken place, and your trial window is there, and you go straight to trial. So at that stage, in my respectful view, what should have happened is, I think that evidence should have been struck, because it's not pleaded, and it could have easily been struck if evidential objection was taken to it. None was taken, but the alternative to that is to say, well, look, I will deal with it in cross-examination, and put it to him, well, if these reports, I mean, this is the crux of the case. You're saying that you gave monthly reports. Where are these reports? You were the man who prepared them.
Right. So you didn't produce them on standard disclosure, not surprisingly, you would say. But what didn't happen was they didn't say, oh, we're relying on these reports that Mr. Paul supposedly sent to Mr. Boyce. Where are they? And that would have notified you that that was going to be there.
Absolutely.
Yes.
Or something
Absolutely.
that they didn't ask you to search for them.
No.
And do we have any reports, any of these monthly reports?
No. And I'm ready to fly in the ointment with that further, is to bear in mind that we can't make the presumption that these reports were actually received by my client. We don't know.
Well, we know no idea what they actually said anyway.
Yeah.
They could have just reported on work being done without saying anything about it being a variation.
Well, there's no evidence. There's just no evidence, and the burden of proof is on the claimant to prove his case. And insofar as this is a critical part of their case, we say they fell woefully short. And the trial judge who listened to the cross-examination of Mr. Barry Paul, and when the counsel put to him, put all of this to him and asked him, well, where are these reports? And he said, well, it's not there. I didn't produce it. I mean, she was right. When you look at the cross-examination, she was right to reject this man's evidence. She plainly didn't think he was a credible witness.
Well, unfortunately, she didn't say so. It might have been helpful if she'd said a bit more in her judgment about her reasons for coming to her conclusions.
Oh, my Lord, I do agree.
She was very good at setting out the evidence, but not so good at actually saying what she thought about it.
Yes, my Lord, I often cringe when I see, when I read judgments where 90% is a recital of the evidence and 10% is, a skirting.
10%'s quite generous, I think.
But my Lord, I have the good fortune or misfortune of having done the recent case of Christo Giff and Dr. Keith Rowley before the board. And, in that judgment, the board restored the trial judge's judgment, notwithstanding what I will say
Well, you might be stretching it a bit to try and rely on that case on this occasion, I would have thought.
Well,
I mean, it really isn't good enough, is it, to say something like some, if not most, of the circumstances without even fall within the scope of the contract, without even saying which.
Lord,
I mean, one can't say that the trial judge's findings shouldn't be disturbed in that situation.
No.
One realistically
I accept.
has to be reassessed.
I accept that. My Lord, in the early days when I was a student at Queen Mary, one of my professors told me, knowing your judge is more important than knowing the law. I remember it today because in Trinidad, the system is heavily overburdened. Judges are overworked and underpaid. It's a reality there as in many other countries.
But it's apparent how long it takes. The judgment comes out a year later.
No, I agree, and I'm not here to make any excuse for the...
No, I'm just saying it's a sign of the system must be under immense pressure.
Well, my lord, it is. I mean, look, you know, the board is aware of this. It's an open secret. But the point is, sometimes that accounts for the brevity in the judgments. And also, as well, insofar as I made the quip about knowing your judge, different judges have different styles of drafting their judgments. This is actually the same judge who was the trial judge in the Rowley matter.
But there's a big difference, because in that case, we were talking about findings of fact.
Yes.
In this case, we're not talking about findings of fact. The facts, the primary facts, are not in dispute. The work that was done by the contractor is agreed. The question is whether it fell within the contract or not.
Yes.
That's not a question of fact.
Well, and to the extent that it didn't, whether the variations were in accordance with the contract.
But I mean, it's quite a different case from the Christo and Gift case, because we're not here concerned with findings of primary fact.
Well, Lord, I have to say I've been thinking about it, and I can see why. You know, on one hand, we can say it really doesn't involve findings of fact. But the way the cross-examination went in this matter, when you look at the written submissions before the trial judge, I think the issue that she had to decide was, there's an agreement between the parties, and what is that agreement? It's the written contract. Yeah. And did the parties fully appreciate and understand this contract such that they intended to be bound by it? I mean, that's why the council took them through on a clause by clause. Well,
that was a waste of time, actually, wasn't it? Because if you've signed up to the contract, you're bound by it, and what you thought or whether you read it doesn't matter a row of beans, actually.
I see the...
I looked at the cross-examination. There was a lot of it reading out clause 4.1 or something and say, do you understand that? And the witness would say, yes, I do understand it. Counsel would say, oh, good, and then would come on and read the next clause out.
It was like a rereading of the contract. It was short on interrogation of the actual evidence. I accept that, my lord.
I think it would be fair to say that both judgments are rather short on any analysis of the contract.
Yes.
And if my lord is right that variations, it's a question of is it in the contract or not, neither judgment really addresses that at all.
I think that's a fair comment, my lord, and I concur with that observation.
So I think on the factual point is, I think you're saying, or you would accept that if they had produced a series of reports that Paul had written to Mr. Boyce as the project manager, and Paul had been saying, they've said they need to do this, it's going to cost a bit more, is that all right with you? And if Boyce had written back saying, yes, I suppose so, we'll have to pay extra for that, then you would be in a much more difficult position than you would say you're in now.
Absolutely.
But the Court of Appeal seemed to have thought that it was made out that the high-ups, more senior to Mr. Paul, had agreed all this, and you say there was no factual basis for that. Indeed.
And that's why, my Lord Richards, the short point is, to the extent, for example, that the Court of Appeal said that the testimony of Barry Paul was the clincher. I mean, to the extent that that testimony, which was obviously, pivotal in the case, but to the extent that the trial judge clearly doesn't focus on it in her judgment. Based on what the board said in Rowley, what I asked the board to say now is that it is an implicit rejection of his evidence by the trial judge. There's no way the trial judge could not have rejected his evidence because, or rather accepted it and come to and deal with the judgment in the way that she did. In the Rowley matter, you would recall that Justice of Mendonça had overturned the trial judge because there was critical contemporaneous documentary evidence. And he was saying, well, look, you couldn't possibly decide the case without confronting the document, the contemporaneous documentary evidence, which is of immense and high probative value in any case. And what the board said is, well, you can't assume, because it's not mentioned in the judgment, that the judge didn't have it in her mind. And more importantly, they turned it around against me, as it were, and said, well, it is precisely because you say it's so important and critical evidence that it would be unthinkable to suggest that the trial judge did not have it in mind and did not consider it when writing the judgment. So that it's a virtual presumption, as it were, that the trial judge would have considered all the material facts and evidence in the course of writing her judgment. And what the board said is that it is not necessary for them to necessarily condescend to give particulars by rote of every single aspect of it. But I accept.
Well, that's all true, but unfortunately here we don't really even have a reasoned judgment, it has to be said, at all.
Well, my lord, I can't argue too much of that, but I mean,
So, I mean, regardless of what happened below,
Yeah.
what we're concerned with is firstly whether this work amounted to variations of the contract.
Yes.
And to the extent that it did, what's the consequences of failing to follow the contractual procedure?
Yes, well,
Essential issues.
and there's an intermediate question as to whether or not the variations fall within the contemplated permutations and dynamics of the contract, because the contract does.
Oh, that's the first question, I think.
Yes. So, So, because it's only if it falls outside of what's contemplated by in the inherent flexibility within the contract that then you go to the other issue.
Is it extra work?
Yes.
Yes.
In other words, it's only if it's a variation to the scope of works that you need to consider that. But if it falls within the framework of the existing contract, then you don't need it. And we say, it does.
Well, that's what we're expecting you to argue.
Sorry?
That's what we're expecting you to provide some arguments to support.
That's what we'd like you to move on to.
Yes, my lord. Now, my lord, my lord, if I may say, at the risk of sounding trite, I mean, the role of the court in contract disputes is to really give effect to the contract that has been agreed to by the parties. These parties intended to create legal relations. They went into this with their eyes wide open. It's a commercial contract. And that contract, to the extent that it has these procedural safeguards, for both parties, quite frankly, it's something that we say should be respected and judicial deference ought properly to be paid to it.
I don't think we've got to the procedural safeguards yet. We're expecting you to address what the scope of the works was in the contract and whether the work that they claimed for comes within that or not.
Well, yes, my lord. Well, my lord.
Because if you're right that it was all within the scope of the works, then that's the end of the case anyway.
Of course,
so.
of course, my lord. My lord, with that in mind, can I then? My lord, in the agreed facts between the parties, you will see that there's a list of documents that comprise the contract. It's at page 1489 of the record. And it's a long list of things, including the bid documents and the like. And at G, you have the tender, including the invitation to bid and the minutes of the meetings and so on. And I just want to make the point that that includes the preamble to the bill of quantities as well. My lord, the 4 areas of concern are the cutting of the asphalt roadway for the laying of the pipe, the removal of excavated material over and above what was envisaged, importation of backfill material, and carrying out of nighttime work. Now, the circumstances in which this arose was that contrary to the original design by the contractor, which envisaged that the pipe would have been laid on the verge, it transpired that it required to be laid on the roadway. Now, let's pause there. There is no evidence from the respondent claimant in this matter as to what led to that change in its design. They were responsible for the design, and there is no evidence from them, and they bear the burden of proof, to explain, well, why was it necessary to move the pipeline from the verge and to put it in the road? Nothing.
So that's a change from the preliminary design to the final design.
Yes.
and the contract says that both the preliminary design and the final design are the responsibility of the contractor.
Indeed. And we say that is the seminal change that led to all these variations, as it were. Because as a result of that, obviously, if you're moving from the verge on the side of the road and you're going to do it, put it in late in the road, now you have to obviously excavate the asphalt. You've got to cut the road. You've got to, get the backfill removed, and there'll be more backfill if it was on the verge as opposed to the road. But all of the things that were prompted by this arose directly out of that.
So the unsuitability of the excavated stuff to be used as backfill was the result of the fact that the trenches were under the asphalt rather than along the verge, is that what it's
Correct.
Okay.
Correct.
So where do we see that the design was based on it being on the verge rather than on the road? Is that in some drawing, or is it described somewhere?
My Lord, I have not been able to. There are no drawings. We've searched in the record. There were no drawings. But insofar as the contractor was responsible for designing this, it would have to be their responsibility ultimately. They accept responsibility for the design of the work. And if they, that's the whole point in the site inspections. There is evidence from the appellant to say, well, look, you're free to go as many times as you wish to inspect the site with or without us. And contractors would do that. They would go with their engineers, they would go with their crew, and they would formulate their bid proposals based on that. So if they felt that if they designed this with laying it on the using the verge as opposed to the roadway, and after we have entered into this contract for a specific project for a specific delivery date, in those circumstances, well, they carried the risk.
Did their bid specify the location of the pipeline?
Yeah, my Lord, no, the bid did not specify it, and again, their witnesses did not give any evidence on this issue. There's a conspicuous silence by the appellant, by the respondent, claimant, on this critical, seminal issue, which is what led to all this alleged extra work. They had the duty, the burden of proof as a claimant to explain, look, this is what went wrong with the design. There was a fundamental flaw in the design. We had to move it from the verge to the road, and this is what, they had to explain all of that. You're coming close to the limitation period. You certainly you had 4 years to think about it, but there is simply no pleading. There is no evidence about it. Nothing. And as I say, when one looks at all that is triggered by this one change, it is clear that as a result, the asphalt had to be cut and excavated.
The cutting of the asphalt was envisaged in the contract.
Yes,
take, for example, page 553, 3.1 of the specification. When excavation trenches in carriageways or surface footpaths, the contractor shall first cut through the surface asphalt.
Yes, I'm not, and that speaks to the dynamism and flexibility in the contract. Because if you're going to lay pipelines, one can readily appreciate that you might encounter a situation where the pipeline might have to, it might not just carry a straight path, and it might become necessary to actually run it across the roadway. You might have to have a crossing and all sorts of things, but that's within the contemplation of the contract. So that even so, as my Lord quite rightly observes, it is something that was within the contemplation of the contract itself. And insofar as the excavated material was unsuitable, it's a bit like the eggshell skull principle in the law of tort. You take your victim as you find them, but you take the site as you find it, and you take your design as you submitted it. And it's your job to implement it.
It goes a bit beyond that, doesn't it? Because there are provisions in this document which specifically envisage that the contractor is responsible for removing any material and for providing backfill if required.
Yes,
For example, on, I think 314 is it, of this?
Yeah, my lord, they don't disavow that. Their complaint is that it was a little excess material, right?
I think on page 557,
Yeah.
at the top of the page.
Yes, backfill to trenches and, in general, yes, obtained from, yeah, backfill to trenches.
Where backfill of the specified class is not available as dug,
Yes,
the
Processing.
contractor shall import the appropriate backfilling material.
Yes.
So they're saying if you can't use what you dig out as backfill, then you've got to provide it.
yeah, which stands to reason, but that's why even when the cross-examination was taking place, there was some questioning about borehole testing and all of that, because as you'd appreciate, when you're going to design and bid, you can do your borehole testing to ensure that, to see do a soil sample and a soil test to see, get it analyzed, and then you'd be able to have an idea as to what type of soil it is and so on. As to whether they did that or not, that's a matter for them, but the point is they bid on a particular basis, and as my lord quite rightly points out, the contract had within its contemplation that, you know, what you excavate may not be capable of being reused, and you might have to import. I mean, it's a matter of basic common sense. And then, and that brings us to the last one, which is the nighttime working. Again, the contract speaks to daytime hours, but to the extent that the contractor opted to work in the night because to minimize...
Day work is nothing to do with whether it's done during daylight hours. That's just the way it's charged for, isn't it?
Indeed, indeed, indeed. So that, Melody, it's the rate that is important. And this, we say, it really is a bit of a red herring, quite frankly. The work had to be done. As to the mode of performance and to when and how you do it is a matter for you, quite frankly. It's not a matter that should trouble us.
But I thought in your written case, you accepted that the night works was something that was not properly included. But are you going back from that? It was something additional to the contract, to which, if they'd followed the right procedures, they needed to...
Paragraph 25A.
Yes, my lord, I do.
Are you rethinking that?
I think, I mean, we did that because the contract itself had normal working hours, 7 a.m. to 6 p.m. So that's why we made that point.
Well, where do you stand on it now?
My lord, I say that, look, how the work is done and when it is done is a matter for the contractor. To the extent that it is the flawed design, to the extent that that prompted all of this. It is the causative event that led to the works having to be done in the night, that led to the backfill, the excavation of the asphalt. Everything is linked back to the fixed price lump sum contract bid that you designed and provided. What if another contractor had bid $2 million more, but the integrity of but they had said they'd run the pipe on the road instead of on the verge? I mean, even if WASA said we wanted it on the verge, you have to make your own assessment, and you design and you build and you price. That's how it works. It's a bit like a conceptual tender.
And you say you're saying now that that goes for when you do the work as well.
Yes. There is no evidence that this increase in price as a variation it's not a variation to the scope of work, it's a variation in terms of the working hours. There's
no separately quantified claim for the nighttime working, or is there?
I think there is. Was it 300? I think in Raymond Thomas's witness statement they did quantify it, Melody.
Okay.
I mean, how was it pleaded by the claimant in its statement of claim, the night working?
No, my lord, that's part of the problem in this case. What they've done is to simply throw a lump sum figure at the court.
Or in the pleading?
Yes. We can. Yeah. If we go to the statement of case, it starts at page 7, and you will see
the nighttime working is at page 11, paragraph 17, and it makes the point I think you were making a moment ago, because it starts in an attempt to make up for the lost time due to the unforeseen delays, and that's a reference back to the backfilling and the cutting through asphalt.
Indeed.
And then it says, and to alleviate the traffic congestion. And then it says, orally agreed work would be done at night as well. So it looks to be pleaded as being the consequence of the previous variations which had caused delay.
Yes. And that's why I make the submission, my lord, that it's, I mean, all of this was triggered by the decision of the contractor to switch from the verge to laying the pipes in the road. And there is a gaping hole in the claimant's case in terms of the evidence as to why that switch was made. Yeah.
And they don't break down the claim so that there's a specific element for
No. And that's, my lord, I'll employ you to have some sympathy for the trial judge on this score, insofar as she said that when it came to damages, she said it just didn't, you can't, I think her words was, you can't fling, you flung everything at the court, but without particularizing it and without actually condescending to prove your claim for damages. That's what she said in her judgment. You've just flung everything at the court, kitchen sink and all, and there is absolutely no attempt to prove the claim for damages.
So they had put in invoices, but there was, you're saying there was no material backing up that?
No, my lady, the invoices were all unpaid. There's no evidence that the invoices were paid. No evidence was led to show that there isn't a scintilla of evidence to say, well, we actually paid these invoices.
Oh, the contractor paid?
Yes, that the contract, yes, but he's the one seeking to recover. But he led no evidence.
Oh, you mean because he was claiming for cost of subcontractors, was he? Is that
Sorry?
Materials.
or material?
Yes.
But what about the nighttime working? I was focusing on that in particular. That wasn't quantified.
There was no... There was no documentary evidence in support of that, my lord. No. In contradistinction to the invoices submitted in respect of the other heads.
Right.
No, nothing. No. My lords, and one can. In that regard, my lord, now, can I just...
Just on that lump sum claim, so paragraph 33 talks about...
33 of the statement of case?
Statement of case,
Yeah,
a
much
breakdown
obliged.
of works done and costs incurred are annexed in a bundle. Is that right?
Yes. Now, my lord, that's a document that they had submitted some time ago, and they've annexed it, but as the trial judge says, I mean, I don't know that it's right to simply annex that without properly pleading your case, to set out in the statement of case itself what is your breakdown and more.
Was that document then something that they had sent after the event to the
Appellant.
employer to
Yes.
say this is what we're claiming?
Yes.
Do you have the page?
After the contract was terminated. Sorry, my lord?
Do you have the page for that?
708, I'm advised, my lord.
708.
708, yes.
385 is UBCL 10. This is the so-called breakdown. Oh, no, it's not there.
Yeah, 708 would be the claim for package 1 that they had submitted. And this is all after the contract had been eventually terminated. And then there's the package 2 is...
Oh, I see. So which page did you say?
708.
That was the claim.
Yeah. And then it follows, what follows is the 716 is the breakdown.
Oh, right.
Of what was at 708?
Yes. And then we have the other package which follows a similar format.
Okay, so there is, in fact, they have quantified the nighttime work.
At number 7 on page 716. No, sorry, beg your pardon.
Number 6,
Number
item 6.
Six, yes. Well, as we're on this page, there's one minor item I just wanted to raise, and it's item number 7, loss of profits. You will see that they've made, in this claim they've submitted to us, and it's part of the claim before you, and you will also see it at page 712. They are claiming for a loss of profit element, which is not pleaded, and it's not particularized in any great with any, there was no attempt really to prove it at the trial. And in the Court of Appeal, one of our complaints is that the Court of Appeal allowed this as well, and we say that that's, you know, the loss of the opportunity to pave the road that has been brought about, you know, that shouldn't have featured in their claim at all. Package 2, which follows a similar format, is at page, the claim for package 2. It's at 733, you'll see the breakdown. And it follows a similar thing, similar pact. And there's at item 7, that loss of profits. It was again. And then you have the item 6, the charge out rates for additional manpower, extra resources that were used in the execution of the works during the night. And this has become necessary because of traffic congestion during the day.
Is 733, is that package 2?
Yes, it is, my lady, yes. Where is package? And that claim is for package 2, that's 724. So 724 particularized in 733.
You mean the other way around?
Yeah,
Oh, so, yes. Sorry.
So at the beginning, you gave us some figures as to what they paid, what they've been paid. So they have so far been paid less than the contract price, and that was
up to the point when it was terminated. Remember, they didn't get it completed, but up to the time it was terminated, they were paid $21 million.
right.
Was the loss of profit premised on the contract having been wrongfully terminated early or something like that? Or was there no pleaded... I mean, what was the pleaded basis for the loss of profit claim? I
mean, the way... I think it's... The way it's framed, it's loss of profits for one component of the work, which is the paving of the road. They lost the opportunity to complete the paving, to do the paving works. And
that's because the contract was terminated?
Yes. And we had to hire someone else to do the paving because we weren't, you know, things were unraveling. But the point is, they are claiming the loss of profit for the opportunity, the lost opportunity to pave the road, and they've quantified it at that sum. So that's what that is. Now, my lords, can I just quickly move on a bit to deal with some of the other areas in the case? I think we are, it's important to know, if I can take you to page 161, just to show you that the word variation at 1.169 is defined in the contract, and it tells us that it means any change to the employer's requirements or works which is instructed or approved as a variation under clause 13.
And both employers' requirements and works are themselves separately defined.
Yes, indeed, my lord, indeed, indeed. And the short point is that it's linked to clause 13, so that the concept of a variation, the definition of it, expressly incorporates clause 13. And if I can take you next to page 172. You will see that at you will see at 411, The contractor shall be deemed to have satisfied himself as to the correctness and sufficiency of the accepted contract amount. And at the bottom it says, unless otherwise stated in the contract, the accepted contract amount covers all the contractor's obligations under the contract, including those provisional sums, if any, and all things necessary for the proper design, execution, and completion of the works and the remedying of any defects. In 4.12, unforeseeable physical conditions, they treat with natural physical conditions, and they say, if the contractor, in the second paragraph, if the contractor encounters adverse physical conditions which he considers to have been unforeseeable, he shall give notice to the engineer as soon as possible. And the notice shall describe the physical conditions so that they can be inspected by the engineer and set out the reasons why the engineer considers them to be unforeseeable.
Are we concerned with that? I know that the original statement of case was put on the basis of unforeseeable ground conditions, but there were findings neither by the first instance judge nor the Court of Appeal that this was an unforeseeable ground conditions case.
My Lord is correct, and I reference it only to point out that insofar as it was their pleaded case, they would have been obliged in any event to comply with Clause 13, and there's no evidence that the appropriate notices were given within the prescribed time in accordance with the contract.
And then claim a price increase pursuant to Clause 21.1.
Yes, indeed. Can I take you next to page 215.
Sorry, give me the page again.
215.
Thank you.
Clause 20. If the contractor considers himself to be entitled to an extension of time for completion and or any additional payment under any clause of these conditions, or otherwise in connection with the contract, and I want to stress the words and or any additional payment, the contractor shall give notice to the engineer describing the event and or circumstances giving rise to the claim. The notice shall be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. And what's important is the clause, paragraph beneath. If the contractor fails to give notice of a claim within such period of 28 days, the time for completion shall not be extended. The contractor shall not be liable to additional payment, and the employer shall be discharged from all liability in connection with the claim. So that there is no, clearly this was an additional payment that's been requested by the contractor. Again, there was no attempt to comply with this provision. But what is significant about it is you're absolved from liability if you don't give notice within the 28-day period, and the procedure here with the engineer is followed.
When does, if there is an extra payment agreed, when does it become payable? When does the amount become payable? If there's extra work.
Well, it will depend. It will depend on whether the extra work falls within the contract or. Well,
if it falls within the contract, then you have no claim for extra payment.
Well, no. If it could be something. Remember, you have a contingency fund in the contract that caters for some element of flexibility in terms of extra in inverted commas works. So it could be that you could pay it out. You dip into the contingency fund and pay it.
Well,
but.
When do you say that if there was any entitlement to an additional payment so that this clause would be triggered at all, when did that entitlement arise?
I would say...
It starts off saying if the contractor considers himself entitled to, we're not concerned extension of time here, any additional payment, so that presumably is when 28 days starts to run.
Yes.
So when would... Well, contractor, if he was entitled to additional payments here, when would they have become due?
Well, they would have become due when he serves the notice. If the employer accepts that the works are justified and they give their approval, then payment will become due at that stage.
Is that right? Okay.
Yeah, and I'm reminded by my junior, but you'll have to proceed in accordance with clause 3.5. So that, I mean, once that procedure is complied with, then yes, I accept that it would become, you'd be liable to pay.
I'm a little lost here. I thought the contractor was putting its claim on the basis of an agreed variation.
Yeah.
And if there's an agreed variation, then does not the engineer fix what the price will be for the extra work? Isn't that all taken care of in clause 13?
Well, my lord, yeah, that's correct, save and except that you can't have an agreed variation without the prescription for...
Well, I understand that, but my point is I don't understand the relevance at the minute. I don't understand the relevance of clause 20.1. Because that, as I understand it, that's not the way the contractor puts its case.
No, you're right, my lord. It's not. They did not put, they did not put their case on that basis. I accept that, my lord. Can I go to page 283? My lord, what I'm doing is just showing how the contract is carefully calibrated to treat with different situations, and they could have, for example, invoked that, as it were. At page 283, the employer's contingency, at P13 at the bottom of the page. An amount included to cover the cost of any variations that may be instructed by the employer or the employer's representative. Specific amounts have been inserted in the bill of quantities by the employer. These amounts shall only be paid to the contractor in whole or in part upon issuance of a variation to the contract price and certification by the employer. So,
So that would be the trigger for payment?
Yes, my lord, yes. But it's got to be all done in accordance with the contract, so it has to be done. There's a heavy emphasis on contemporaneous written documents in this contract.
So I thought this was to deal with if the employer decides, all right, we asked you for 28 point whatever miles, actually now we want it to go further, so we're going to vary the contract to add another 5 miles of pipe.
Yes.
Then is that what the contingency is?
I mean, lady, it might be both, but insofar as their case is that it was an agreed variation at the request of the employer, I draw it to your attention simply to say that it doesn't take them very far, because it's the clause itself speaks to a variation to the contract price and certification by the employer, and all of that, again, certificates under 1.3 have to be in writing. And I don't want to belabor the point, but throughout this contract, it is punctuated by constant references to contemporaneous written records. Everything that in terms of a variation, the procedure, there's a heavy emphasis on the need for a contemporaneous written record. And the reason for that is obvious. It's to have a proper record, and so that the public authority can ensure that when it makes the expenditure, if it does so in a transparent manner that can withstand public scrutiny, quite frankly. Because, milady, if a public authority...
Well, this is a contract which doesn't need to be a public authority, which is the employer, does it?
I accept that, but in this case...
Yes, but, I mean, in terms of construing and applying the contract, it's irrelevant that it's a public authority, isn't it?
Well, Lord,
I mean, supposing a private enterprise had engaged a contractor on...
It would be the same.
Yes,
exactly. The protection will be will be the same.
Yeah.
All I'm saying is that there's an enhanced perspective, a different perspective with the public authority, because they are subjected to public scrutiny.
Yes, but it doesn't affect the construction and application.
Fair enough. That's fine, my lord. I accept that. I accept that. So, my lord, in summary, we say on a proper construction, it was a fixed price lump sum contract meant to cover any and all eventualities, express or implied, including all accidental and contingent expenses and risks of every kind. Variations to the contract's performance were permitted where instructed according to the contract, but payment for those were accounted for within the lump sum contract in the form of the employer's contingency. And the respondent was expected to have satisfied itself that the contract price was sufficient and factored in all the contingencies and circumstances that may arise. My Lord,
Well, should we look at 168 as well, clause 3.5? Is that important?
3.5, 68?
168 is
Well, yes, my Lord. Yes.
This clause 13.3 refers you to 3.5.
Of course, my Lord, there are many cross-references. They all 3.5 is the umbilical cord to many of the other clauses, my Lord. And it says this. I'm grateful, my Lord. Thank you. It says, wherever these conditions provide that the engineer shall proceed in accordance with this subclause 3.5 to agree or to determine any matter, the engineer shall consult with each party in an endeavor to reach agreement. If agreement is not achieved, the engineer shall make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. The engineer shall give notice to both parties of each agreement or determination with supporting particulars. Each party shall give effect to each agreement or determination unless and until revised under clause 20, which we've just looked at. I want to make a few points on this clause. The first is the role of the engineer. It's almost like he has a quasi-judicial role because it uses legal language. He has to consult with the parties and he has to make a determination. He is put in the role of an umpire. So he is divorced from the two parties in the fray, the employer and the contractor. And insofar as he has this independent, neutral role, under clause 3.5, I say that is a solid reason as to why we cannot say that his actions and conduct will bind the public authority. Because he has to inform the public authority and consult with it. And he has to make an independent determination. So that insofar as he has this peculiar role in the contract administration, my point is that it's all the more important to have regard to his relationship.
If he does make a firm determination following consultation, then that does bind the employer.
Oh yes, it does, milady. But what I'm saying is, insofar as he doesn't give the employer an opportunity to consult, insofar as the respondent's case is, he agreed to X, Y, and Z, and he did all of this. I'm saying, well,
What do you say the contractor should do? Suppose the engineer does instruct a variation, but then he fails to go through this process.
Well,
what is the contractor, just to understand how the contract's meant to work, what does the contractor then need to do?
It's important because the obligations imposed by the contract are imposed on both parties to the contract. So what he should do is comply insofar as his duties and obligations under the contract goes. He must comply and fulfill his duties.
Yeah, well, what are they?
Well, my lord, he must put it in writing. He must put it in writing, and if the engineer is not acting, he can notify the employer directly.
Well,
or he can issue a notice under the dispute resolution clause that we looked at in clause 20.
He can invoke clause 20 then?
Yes. It becomes a dispute.
So this applies whenever there's an adjustment to the price because of variation.
Yes.
There has to be determination. Was there any evidence that the engineer consulted with the employer and endeavoured to reach an agreement?
None. None, my lord, none. There is no averment by the respondent that the contractor, that the engineer consulted with the public authority. The closest you get to that is the undisclosed monthly reports, which emerged for the first time in his witness statement.
But that's hardly a consultation with a view to arriving at a determination.
Indeed, my lord. It's the closest you can come, but it's a mile away.
Yeah.
But was he asked whether he had negotiated the price? I mean, UBC put forward these invoices, this is the extra money we want. Was there any evidence that Mr. Paul had said, that's too much, I'll agree half that, or...
No, there's no evidence. There's no evidence.
There's no evidence of him sort of trying to bargain them down on the behalf of the employer as to what they're going to charge for all this work.
There's no evidence, and there was no positive averment about that, and they had the engineer testifying for them, rather curiously.
Yeah, but he could testify. I did my best on behalf
of course,
of
yes,
the authority, and I got the price down, but there's nothing like that.
Absolutely, and he was one of their primary witnesses, who the Court of Appeal said was the whose evidence was the clincher and the deciding factor.
So, if the position was, as a matter of fact, let's suppose that Mr. Paul did give instructions for variations, but then did nothing to consult or anything about that. Once the contractor realised that there was no provision being made for any additional payment for the variations that the engineer had instructed, then it was up to the contractor to invoke clause 20.1, is that right?
Indeed, my lord.
Within 28 days of
indeed,
that.
Indeed. And my lord, might I just say that on that question, there is no dispute that there was no consultation, because in the cross-examination at page, if I can take to page 1023, in the cross-examination of Mr. Paul himself.
Page, sorry.
Page 1023, 1023.
Thank you.
You will see it was a lengthy cross-examination, but look, it ended by saying, at the top of 1023, and the contractor's proposal for adjustment to the price, yes. And it also requires your compliance with subclause 3.5 determination, yes. But those were not complied with. No, I did not follow the procedure. So and that is repeated throughout the cross-examination. So the respondent's own primary witness, accepted throughout cross-examination that he did not comply with clause 3.5 and the procedures in the contract. There is no dispute on that. Plus, we did cite an old case from 1873, Sharp and San Paulo Railway. I don't intend to trouble my lords, except to say that it made for interesting reading to show, how the common law has developed. But in that case, as way back then, it was very interesting that the principles that we are discussing here were crystallized, and they had no difficulty in saying that if you didn't comply with the procedures in the contract, out you go. And I do commend it to my lords, having regard to its vintage and the fact that it stood the test of time, as it were. Now, can I just take you briefly to the trial judge's judgment at page 1199? We've got the long run-up in terms of reciting the evidence, and then we've got the analysis starting at paragraph 112 at page 1199. And she says, second sentence, the contract terms followed the FIDIC model, and in this court's opinion, catered for all eventualities, unforeseen circumstances, and delays that could have been anticipated in a project like this. The contract would have provided for supervision, notifications, approval processes, and for variations. The court therefore finds that there was no need to imply terms into this contract in an effort to make it more reasonable or workable in favor of either party. The court finds...
Sorry to interrupt you, just pausing there. I didn't understand that. There's quite a bit about implied terms in this judgment, and I'm afraid, I'm sure it's my fault, it just went completely over my head because the claimants weren't suggesting there were implied terms.
No, I think it's missed the mark. It's missed the mark. It's respectfully.
So we don't need to worry about that.
No. I don't think the board needs to trouble
itself. It's not just me.
No, it's not. It's me as well. I think to be fair, maybe what the trial judge was trying to say is that maybe they wanted to say you need to imply a term into the contract that if the engineer, somehow authorizes the work that by necessary implication, the employer is liable to pay, regardless of Clause 13 and all the other provisions.
That was sort of what the Court of Appeal said. Oh, well, it's very unfair, and so we imply whatever we need to imply to get to a fair result.
Yes, it was a bit of a palm tree justice approach taken, milady. So, this court finds that the claimant chose to deviate from the express terms of the contract with WASA, for example, with the night works engagement, and did so at its own risk, and for its own account outside of the fixed price of the contract. In fact, this court accepts that the fixed price agreed upon between the parties took into account some, if not most, of the eventualities and circumstances which occurred during the course of the project. The court notes
that's a bit unfortunate, that last statement, because it's inconsistent with the finding that it took into account all the contingencies that arose,
yes,
which is what you would have thought was the thrust of what the judge was meaning to say.
Yes, it might have been a sentence that was tacked on from a different paragraph towards the end, but yes, I accept that it's...
I think, to be fair to the judge, I think there were other things which they ended up not actually claiming for, that they said they'd done in addition. But
it's not in terms limited to what's claimed in this action. I think perhaps it could, that may be said of it.
No. And then, crucially, in paragraph 115, the court also notes in relation to the quantum that has been sought by the claimant in this matter, a figure in excess of $13 million has not been sufficiently supported by evidence to demonstrate the quantum of damages claimed. The court will not accept that it must award special damages which were essentially thrown at the head of the court in the hope that they will stick. A plethora of cases recite that special damages must not only be specifically pleaded but proven. As far as this court is concerned, the claimant has failed to prove its damages. So we say in any event, even if they got the established liability, the judge, we say this was not a plainly wrong finding on the evidence, that they just didn't persuade the court.
So they put in all these invoices, but there was no material to back up the fact that these sums were actually paid by them, and therefore due.
But they called a witness to say they were paid, hadn't they? I mean, I find it a bit hard to say. Well, I'm not sure that relying on the judgment is the strongest part of your case. I mean, if they had established that all this extra material was outside the scope of the contract, then I would have thought they'd done quite a long way to showing that they incurred some cost in paying for it.
Yeah, and they didn't. No. So on this particular paragraph 115, we see it's...
I mean, insofar as we're concerned with what should be paid for variations, is that a matter of damages anyway?
It shouldn't.
I thought the procedure was that a variation was agreed and a price was attached to it.
You'll have to comply with the engineer making the determination. Yes. Yeah.
I mean, that's their entitlement to payment. I mean, there was also a claim by them for a...
that was a loss of profits.
Yes, and repudiatory breach of contract. Well, they said that the employer's termination of the contract was itself a breach of contract, and they claimed damages for termination of the contract, I think. So this may be a reference to that. But we're really focused here, aren't we, on what's due in respect of the alleged variations.
Yes.
And that shouldn't be a matter of damages, should it? Or if I misunderstood?
Well, insofar as the Court of Appeal said the contract having been terminated, the only option... Well,
that's a different thing. Yeah. But we're talking here about work that they said they did pursuant to contractual variations.
Yes.
Before termination.
That should have been resolved by reference.
Before termination, yes.
Yeah, that should have been resolved by reference to
the
procedure in 3.5,
Was there evidence that as well as approving the variations or instructing them, the engineer actually fixed a price for them?
No, none.
Yeah.
Okay, well, maybe there would be. I suppose if there were instructed variations but no price fixed, then the contractor would be entitled to some basis of payment, I suppose. I don't know.
Lord, we say, I mean, if the way the contract is drafted, it's either you comply...
Yes, I follow. Yeah. I follow.
Can I then I shan't trouble the board with the Christo gift case. I think the board is well familiar with those principles, and we've set it out in our written case in any event. Can I go to next to page 194? Variations and adjustments. And we've looked at the definition of variation before. Variations may be initiated by the engineer at any time prior to issuing the takeover certificate of works, either by instruction or by request for the contractor to submit a proposal. A variation shall not compromise the omission of any work which is to be carried out by others. The contractor shall execute and be bound by each variation. But that's a variation initiated by the engineer. 13.2, value engineering. The contractor at any time can submit to the engineer a written proposal, which in the contractor's opinion will, if adopted, accelerate completion, reduce costs to the employer of executing the works, improve efficiency, or otherwise be to the benefit of the employer. The proposal shall be prepared at the cost of the contractor and shall include terms listed in subclause 13.3. And 13.3 says, if the engineer requests a proposal prior to instructing a variation, the contractor shall respond in writing. That is, if the engineer is requesting the proposal. And then at the bottom of the page, we have, upon instructing or approving a variation, the engineer shall proceed in accordance with subclause 3.5 determinations to agree to determine adjustments to the contract, price, and schedule of payments. These adjustments shall include reasonable profit and shall take into account the contractor's submissions under clause 13.2, value engineering if applicable. But it's a very detailed and comprehensive code, and none of it was complied with by the contractor. If I go to page 167, you will see this is the engineer's, if I take it from 166, the engineer's authorities and engineer's duty and authority. It's important the engineer shall have no authority to amend the contract. He may exercise authority attributable to him as specified or necessarily to be implied from the contract. If the engineer is required to obtain the approval of the employer before exercising a specified authority, that should be stated in the particular conditions. However, when the engineer exercises a specified authority for which the employer's approval is required, then for the purposes of the contract, it should be deemed to have been given that approval. And what is important is, except as otherwise stated in these conditions, whenever carrying out the duties or exercising authority, specific or implied by the contract, the engineer shall be deemed to act for the employer. The engineer has no authority to relieve either party of any duties, obligations, or responsibilities under this contract. So that's when I said that the contractor has an independent duty to comply with the contract. So even if the employer is not complying, that does not absolve the contractor from complying with the strict provisions and the procedure in the contract. And then, and we say that most importantly, the engineer could not possibly relieve the contractor of his responsibility to comply with the procedure in 13.5. Any approval, check, certificate, consent, examination, inspection, instruction, notice, proposal, request, test, or similar act by the engineer shall not relieve the contractor from any responsibility he has under the contract, including responsibility for errors, omissions, discrepancies, and non-compliances. If I go next to page 162, communications in part 1.3, wherever these conditions provide for the giving of any, or issuing of any approvals, certificates, consents, determinations, notices, and requests, these communications shall be in writing and delivered by hand, sent by mail, or courier, transmitted using any of the agreed systems for electronic transmission. And at the bottom of the page, bottom of that clause, when a notice is issued to a party by the other party or engineer, a copy shall be sent to the engineer or the party as the case may be. At 194, we dealt with that before, variations and adjustments. And if I go to page 242, yeah, and just to make good the point, at 3.3 at page 167, at 3.3 on page 167, you will see instructions of the engineer. The engineer may issue to the contractor at any time instructions which may be necessary for the execution of the works and the remedying of any defects, all in accordance with the contract. The contractor shall only take instructions from the engineer if any instruction constitutes a variation, clause 13 shall apply. The contractor shall comply with the instructions given by the engineer. These instructions shall be given in writing.
Yes, well, but what if they're not?
Well,
It doesn't say it won't be a valid instruction if it's not in writing. It just is an obligation on the engineer to put it in writing as your agent, which he fails to comply with.
Yeah, I suppose the answer would be that the contractor will have to request to ensure that he requests it in writing to protect himself from the consequences that could follow. I take it no further than that, my lord. I take the point. And my lords, if I then go...
Well, because that's what I think you need to engage with, because that's the way they're trying to argue the case against you, which is that the engineer gave instructions for these variations. He may not have put them in writing, but that didn't make them invalid instructions. So that then would have, I think that does then take us to 3.5, doesn't it? In that
It does.
situation?
It takes you right back to 3.5.
And then you go to the analysis that we discussed before. Which
Indeed.
If he doesn't consult, then you have to invoke the dispute resolution procedure.
Indeed. I mean, that's why I said 3.5 is seminal. It's the umbilical cord that is it's interconnected to many different clauses in this contract, but it's the root of the tree. Lords, with that in mind, can I then perhaps turn a bit to the law, because we've, I mean, I don't plan to spend too much time on it, but the board will be aware of this judgment in Rock Advertising. And if I can just take you to page 1804. Now, this judgment was not cited to the Court of Appeal, and it doesn't appear that the Court of Appeal treated with it in the course of its judgment. But it starts at 1804, and the majority judgment delivered by Lord Sumption says, modern litigation rarely raises truly fundamental issues in law of contract. This appeal is exceptional. It raises two of them. The first is whether a contractual term prescribing that an agreement may not be amended, save in writing, on behalf of the parties, no oral modification clause is legally effective. And that's the issue. And we say, by parity of reason, it's the same no oral modification issue that we're addressing here. And at page 1806, paragraph 10, His Lordship says, in my opinion, the law should and does give effect to a contractual provision requiring specified formalities to be observed for a variation. The starting point is that the effect of the rule applied by the Court of Appeal in the present case is to override the parties' intentions. They cannot validly bind themselves as to the manner in which future changes in their legal relations are to be achieved, however clearly they express their intention to do so. As Lord Justice Kitchen observed, that the most powerful consideration in their favor is party autonomy. Party autonomy operates up to the point when the contract is made, but thereafter only to the extent that the contract allows. Nearly all contracts bind the parties to some course of action, and to that extent restricts their autonomy. The real offense against party autonomy is the suggestion that they cannot bind themselves as to the form of any variation, even if that is what they have agreed. There are many cases in which a particular form of agreement is prescribed by statute, and there is no principled reason why parties should not adopt the same principle by agreement. Paragraph 12, letter H. There are at least three reasons for including such clauses. The first, it prevents attempts to undermine written agreements by informal means, a possibility which is open to abuse. For example, raising defenses to summary judgment. Secondly, in circumstances where oral discussions can easily give rise to misunderstandings and crossed purposes, it avoids disputes not just about whether a variation was intended, but also its exact terms. And thirdly, a measure of formality in recording variations makes it easier for corporations to police internal rules restricting the authority to agree them. These are all legitimate commercial reasons for agreeing a clause like clause 7.6. I make these points because the law of contract does not normally obstruct the legitimate intentions of businessmen, except for overriding reasons of public policy. Yet, there is no mischief in no oral modification clauses, nor do they frustrate or contravene any policy of law. And at letter G, on that same page 1807, he says, the widely used code suggests that there is no conceptual inconsistency between a general rule allowing contracts to be made informally and a specific rule that effect will be given to a contract requiring writing for a variation. On page 1808, letter D, he answers the question, but what if the parties make a collateral agreement anyway? And would it otherwise have bound them? And he answers that at the bottom of that paragraph by saying at letter G, but if the clause is relied upon as modifying what would otherwise be the effect of the agreement which contains it, the courts will apply it according to its terms and decline to give effect to the collateral agreement. Cited Lord Justice Longmore, if the parties agree that the written contract is to be the entire contract, it is no business of the courts to tell them that they do not mean what they have said. And that's why at the onset I said the court's role is to give effect to the party's intention. And if the party's intention is to have a detailed, comprehensive contractual code that is internationally accepted in a FIDIC form contract, and it prescribes no oral modification or no oral variation, and has a heavy emphasis and bias on contemporaneous written records instead of oral conversations and agreements, well, then that is something that the board, I think the board ought properly to pay judicial deference in regard to. Because it will undermine a party's legitimate attempt in a commercial contract to eliminate the potential for disputes by having oral conversations without proper written records, as it were. And if I take you to page 1809, paragraph 15, if, as I conclude, there is no conceptual inconsistency between a general rule allowing contracts to be made informally and a specific rule that effect will be given to a contract requiring writing for a variation, then what of the theory that parties who agree an oral variation in spite of a no oral modification clause must have somehow intended to dispense with that clause, which is the respondent's case, really? And Lord Sumption answers it this way. He says, that does not seem to me to follow. What the parties to such a clause have agreed is not that oral variations are forbidden, but that they will be invalid. The mere fact of agreeing to an oral variation is not therefore a contravention of the clause. It is simply the situation to which the clause applies. It is not difficult to record a variation in writing, except perhaps in cases where the variation is so complex that no sensible businessman would do anything else. The natural inference from the party's failure to observe the formal requirements of a no oral modification clause is not that they intended to dispense with it, but that they have overlooked it. If, on the other hand, they had it in mind, they were courting invalidity with their eyes open.
But what do you say to the respondent's argument that this is really a fight between the engineer and the authority, and it's not for us to question how the engineer who's put there by the authority chooses to run this contract? That's an internal matter for them, and if he's agreed to all this money that they don't want to pay, then they must take it up with him.
Well, assuming to protect the employer, the contract to protect the employer specifically makes clear that the engineer does not have that power. That is why the engineer has to consult with the authority and make the determination with the input of the authority under 13.5. It's not that he, and the reason for that is he is the one who makes the determination. He will become a judge in his own cause, as it were, if he is someone who can make the determination without consulting, and then just, it's a recipe for corruption and all sorts of things that can happen, undesirable things that we can foresee. So that the engineer does not have that power. And that's why the contract also specifically says the engineer cannot relieve any one of their responsibilities under the contract. Either party, it says. And he can't amend the contract and he can't waive anything. So that he couldn't possibly relieve the contractor of its responsibilities to put the notices in writing. Neither could he relieve WASA of its responsibilities. And he couldn't grant any waiver, he couldn't modify, he couldn't amend the contract, he couldn't do any of that. So that they're contractually bound by this detailed code, which is an international precedent used throughout the world, as it were. And for good reason. And even though Lord Briggs in his dissent accepted that it is not, that he was not far apart. I'll get the relevant paragraph where he says,
Paragraph 20, page 1810. I don't think our differences in reason would have any significant consequences.
I think, oh my Lord, the paragraph I have is 29. It's at page 1812, 29. Well, we can take it from, we can take it. He says, by contrast, in 28 he says why he disagrees with Lord Sumption, and then in 29 he says, by contrast, I fully agree with Lord Sumption's proposition that parties who orally agree the terms of a variation of the substance of their contractual relationship do not thereby, and without more, impliedly agree to dispense with a non-oral modification clause. Now, that's quite significant because that's the plinth of the respondent's case, that you orally agree to the terms of a variation, and therefore, that without more is an implicit agreement to dispense with the no oral modification clause. And he says, there is, to my mind, a powerful analogy with the way in which the law treats negotiations subject to contract, where parties agree to negotiate or declare that they're negotiating under the subject to contract umbrella, and at the end of those negotiations, reach consensus ad idem, supported by consideration sufficient, but for the umbrella, to give rise to a contract. No binding obligations thereby ensue unless or until they have made a formal written contract or expressly agreed to dispense with that umbrella. Its abandonment will not be implied merely because they have reached full agreement unless such an implication was necessary. And he cites Lord Justice Brightman, where he said, parties could get rid of the qualification of subject to contract only if they both expressly agreed that it should be expunged or if such an agreement was necessarily implied.
Why did he dissent then?
He dissented because of paragraph 28. I should have read it.
I don't think he, strictly speaking, dissented, did he?
I know, it's not a dissent. He arrives at the same conclusion by slightly different reasoning. And it really, my lady, to answer it, you will see in
But, I mean, this is, with respect, slightly beside the point, because it's clear in this contract that the engineer has no authority to alter the contract. We're not talking about an alteration of the contract. I mean, I think what is valuable, if I may say so, in this case, are the reasons that Lord Sumption gives for there being a no oral modification clause, because those are, I think, can be applied to the requirements for written authority and instructions. But it seems to me that's really the limit of the relevance of this authority.
Yes, I accept that, my lord. We say that it is it's a powerful intellectual analogy.
Exactly.
I think it's also helpful in saying that when you see that they're not doing it, how do you interpret that? Do you interpret that as them impliedly agreeing that they won't do it? And he says, no,
No.
you just interpret it as them not complying with the contract.
Yes. He said it goes to invalidity.
Yes, they've overlooked it or whatever.
Yeah.
But it's you don't infer from what they do that they are impliedly agreeing to vary the contract. I mean, putting aside the point about that it expressly says the engineer can't amend the contract.
Yes.
How do you interpret what's happening on the ground?
Yeah, no, I accept that, my lady. It resonates with our case, and we've brought it to the board's attention because, you know, in none of the cases that rock advertising has been applied since it was decided, have they ever been able to overcome that hurdle of saying that, you know, they've waived the clause for, you know, and they've been able to establish a right to pay. None of the cases we've looked at have succeeded. Because they all cite what Lord Briggs said, even in his different reasoning, that something more will be required than just some form of oral agreement. And putting the respondent's case at its highest, we say that that is all. That is as far as you can get, and that doesn't carry you over the finish line. With respect to the issue of the Court of Appeals judgment, we've set out in our written submissions where we think the Court of Appeal went wrong. We say that they seem to have approached it from the standpoint of you know, some idea of fundamental unfairness rather than taking a hard clinical judicial look and analysis at the terms of the contract itself. There was no attempt to apply the terms of the contract and to factor that into the nodes of the decision-making process. And we say that...
My understanding was that they endeavoured to deal with this by saying at 49 that this was not an amendment to the contract. Variations and adjustments were contemplated by the contract. Although in the next paragraph, they then say the engineer waived the requirement.
Yes, yeah.
And you point out in your submissions that that appears to be inconsistent.
Yes.
What do you say about the point that, well, variations to the works were something that the engineer was entitled to instruct?
Well, we come back again, my lord, to the point that such instructions would have to be in writing, and even then, the instruction, if given, the works that were done fell within the framework of the contract in any event.
So, if you vary the works in accordance with the contract, that is something that's envisaged by the contract and therefore not a variation.
Correct.
Of the contract. If you purport to claim where that has not happened, and there are the various procedural elements that haven't been done, then your argument is that is an attempt to amend the contract, and the engineer didn't have the authority to do that.
Correct, my lord. I'm grateful. That is our case.
Yeah.
Otherwise, unless I can be of any further assistance, those are submissions of the appellant.
Right, well, thank you very much, Mr. Rumlow.
Deeply obliged.
So you 5 minutes ahead of schedule. We're due to take a half-hour break. We were contemplating just taking 15 minutes, unless that inconveniences council. Is that all right, Mr. Ali, if we resume, say, at 3 o'clock?
I have no difficulty with that approach, please, my lord.
All right.
My lady.
Thank you very much. We'll adjourn until 3 o'clock.